Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is, what is the right to repair? A conversation with Gordon-Byrne. If you've ever tried to repair your own phone, home appliance, or tractor, you know it's not an easy feat, as original equipment manufacturers or OEMs often restrict such repairs for a host of reasons. Recent calls for reform to make such repairs easier has gained traction amongst consumer protection advocates and antitrust policymakers. In this episode of Our Curious Amalgam, we explain what the right to repair is and how it interrelates with consumer protection and antitrust law. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Christina.
So, right to repair. Why are we talking about it?
Well, because the issues are on the horizon. We're finally talking how consumers, a regular one like you and I, who has a smartphone, or people who are much more sophisticated in terms of fixing their own things, want to fix their own things, find it frustrated. So we are here trying to figure out what exactly are the rights involved. Possibly we're going to talk a little bit about law, but maybe more just about rights and how consumers perceive relevant issues.
Great. And who's our guest today?
Our guest, Gordon-Byrne, is the executive director and a founding member of the Repair Association. You might have heard that because the organization is very much in the forefront of the movement. The Repair Association is a grassroot organization, if I may call it that, that advocates for repair-friendly policies, regulations, statutes, and relevant standards. And Gay, her personal background includes training in systems engineering, systems software support, and a bit of machine programming. In the past several years, Gay has been, as I said, in the forefront of discussions with legislators, trade associations, and opposition lobbyists, examining the issues around what do we call the right to repair.
Great. Well, Gay, it sounds like you actually know how to fix things, unlike myself. But in any event, welcome to the program. We're happy to have you.
Terrific to be here. Thanks for inviting me.
It's our pleasure to have you. So let's go right into it. What exactly is the right to repair? What is that a right a consumer should have? And what exactly are we talking about?
Well, it's a right that we actually do have, but it's so poorly understood that people think that they can't fix their stuff, when in fact they can. There's no violation of copyright law or patent law, and there's no need for trade secrets for you to fix your stuff, because you're supposed to be able to do that because you bought the equipment, you own it. It's the misperception that is causing trouble. So incorrectly, we're calling it a right, like it should have quotes on it, but it doesn't. It's the opportunity to be able to fix your stuff. Much more practical than a legal right.
So if I may go back to my first year in law school, I remember whenever we're talking about property, we're talking about a bundle of rights. We're talking about can I rightfully enjoy it? Can I rightfully transfer it? Can I rightfully perhaps even destroy it? So are we in the same realm here? Are we talking about the right that I have obtained by purchasing whatever device that is in issue? I have the right to open it, to maybe do some fixing of the gadgets, and then have some new function, or maybe just function again. Is that what we're talking about?
Very much so. It is, in fact, a bundle of rights that you already have. And with 20 years of marketing telling consumers that you don't have those rights, I think the perception is that you don't have those rights when in fact you do. The practical problem is that if a manufacturer decides to make it difficult for you to fix your stuff, even though you own it, they can do it very easily. They simply don't sell parts and tools. They don't sell diagnostics. They don't post a manual. They used to print them and send them out. Now you can't even get it at the library. So it's a lack of cooperation on the part of the manufacturers that has created the practical problem that we can't fix our stuff, because legally we can.
And what industries are we mostly concerned with? For instance, a consumer like you and I probably don't own a tractor, but some people do, right? So, but I know that's probably one of the things that we're going to talk about. So, what industries are most impacted, or who have experienced the most frustration in terms of fixing their own stuff?
Well, we all are impacted on everything that we buy if it has a chip in it, because it's the presence of the chip and the opportunity that it provides the manufacturer to restrict access. You can't basically go create a homemade computer chip for your hot tub. You're going to need to buy it from the same company that produced it for the hot tub. And if that can't be done, it affects you. So if you think a little more broadly about where there are chips in your things, you're going to find that there's a lot of chips in your things. People understood this very directly with automobiles. And it was relatively easy to get a law passed in Massachusetts back in 2012 that required auto manufacturers to make those things available to car owners and to independent mechanics. And that's the reason you can fix your car right now, is because of that law. You can't fix your cell phone, and you can't fix your TV, and you probably can't fix most of your home appliances as a consumer, but it also extends to business products as well. Big companies can't fix their computers. They can't fix their communications equipment. They can't fix their production equipment. It's very broad. It's really one problem. It affects just about everything with a chip. So consumers feel it very powerfully with their cell phones, but it really is a much bigger problem.
Mm-hmm. Let me get a little more precise with the word you're using, can't. Does it mean that I'm not capable of, because everything is more complicated now, it's just technically beyond my ability of fixing it? Or meaning can't in the sense that if I do open it and I do try to adjust certain things, and then I'm sort of in breach of certain contract? Or can't, in a sense, it's a trade-off that I do not want to make, right? If I peel off a little label and then I have turned off something, I essentially have lost the warranty that I have on the thing. Which one scenario am I in?
I think you're in all of them. Let's unpack. Let's unpack that. Yes, your choice of what you feel competent to work on is your choice. And without an option of repair from somebody who feels that they have the training and the capabilities, then you can't. We're in that position with a lot of equipment because it's very hard for even a guy that knows how to fix cell phones to fix everything, because he or she will wind up at a point where they literally cannot acquire. Maybe it's a part, maybe it's a tool, maybe it's a diagnostic. There's things that they are not able to buy that cause that problem. Another can't is when things are glued together, because if you can't get into something, you can't fix it. Another very large misunderstanding is that you violate a warranty by fixing your own stuff. As a consumer, there's federal law that says that's not true. It's the Magnuson-Moss Warranty Act of 1975. And that is the law that makes it good for you to go to a local auto mechanic and have your oil changed without losing your engine warranty. Now, in small electronics, where the warranties are very short, like 90 days or a year, the idea that you're going to violate the warranty by opening the device 3 years later is ridiculous, because there's nothing to violate. And that is a violation of Magnuson-Moss, and that's part of why the Federal Trade Commission has become so involved in evaluating anti-competitive problems within the repair industry. And there was another thing that you said, and I can't remember what it was.
The trade-off. So essentially, I have to this is actually a good segue to our next question. There are arguments for and against the situation we're in, right? Why the manufacturers have decided that they are going to restrict certain things that, some consumers will want to do. And is that a trade-off that is made, or a decision that is made on behalf of consumers, right? Is it in a sense that manufacturers decide to forget about it? If you just, open it and fix it, it might explode. And we're not going to allow that to happen, even if that's like a chance like 1 in a million, because human life is too precious. Or I'm just trying to unpack the trade-off I'm trying to talk about, or a decision that's already made. So what's your take on that? What are some arguments for and against the situation that we're in and the decisions that has been made?
If we go back to the design of the products have got to be designed to be repairable at pretty low cost on the part of the manufacturer, because in order for them to make good on their warranties or their service contracts, they can't be sending out a PhD electrical engineer to fix something small. So they will have made, and this applies to more sophisticated products rather than throwaways. But when you get into something that the manufacturer is going to have to support, the equipment itself can be extremely complex. But they have already created the means to repair it so that repair is not complex because of the labor costs. They are going to make it pretty easy to swap a part and reinstall the software. And that's an economic choice on their part. So there's an assumption that stuff is complex that makes it impossible to repair, when in fact that's not true. There are parts assemblies that could be repaired. In fact, there are companies that specialize in repairing parts assemblies, and they do it behind the scenes because they have the schematics. They've got everything they need from the manufacturer, because the manufacturer had hired them to fix the parts so that they will themselves have spare parts. So the complexity issue is kind of a phony one, in that if the manufacturer can fix it, you can fix it. You may choose not to, but the chances are that the 18-year-old kid at the Genius Bar has about as much brains as you do, and you could do whatever they do if you had the information. Manufacturers also have to design products that are safe to use, because if they are not safe to use, and a battery does explode and somebody gets hurt, they become responsible for producing an unsafe product, and that's where you get all the litigation. If they choose a battery shape or size that's not suitable, as we saw with the famous Galaxy, I think it was a 7, that had this, like, the battery would warm up and pinch and blow itself up. I mean, they had to recall millions of units for that. That's a design flaw. That wasn't caused by the person that was using the phone. It was a design flaw. So manufacturers would like us to think that their design flaws become our repair limitations, when it's really not the case. We are assuming that the product is safe to use, and part of use is repair. I mean, if you're designing a flashlight where you can't replace a battery, and without risking it exploding, I think you have a really good case as an unsafe product. And that's what's happening with a lot of these things. And the FTC did look into that pretty extensively and found that for the vast, vast, vast majority of products, there's very little evidence that repair is creating any harm.
I'm sure when we actually get to the realm of torts law, it's going to be much, much more complicated. It varies from state to state. And I wouldn't say I would not encourage anyone to actually open your thing and think you have a case. Just read the fine print and be watchful where you are. There's one thing that I do have to advocate a little bit more, which is, of course, that's more in the interest of the manufacturers, which is trade secrets. So, we probably can agree that there are fair arguments that the manufacturers, they're not in their best interest of disclosing everything, right, in their design. They should be able to enable people who want to fix that with some manuscripts or blueprints, but not everything. So there's some arguments there. So what's your take on that?
Well, I looked at and read the Uniform Trade Secrets Act, and I understand what it is intended to protect. And in the case of repair documentation, I don't see that it passes the test as being a trade secret. If a manufacturer is sharing repair documentation, and schematic diagrams are part of that, with other groups, with subcontractors, like I said, these groups that will repair equipment down to the board level, they're getting that information already. So it kind of loses, it would be very difficult for somebody to say, well, this guy can have it, but this other guy can't have it because it's a trade secret. It kind of doesn't meet the test. And manufacturers, and I used to work for a bunch of manufacturers, and we would never have put a trade secret in anything that would have been distributed. It would be stupid. It would just flatly stupid. You would never do that. So what's required in the legislation that we're promoting is the same stuff, access to the same, not different, not more, but the same as is already in distribution. So I think that kind of takes off that trade secret argument. And schematic diagrams are covered more by copyright law than they are by trade secret law, because they're diagrams. They're considered creative in some very, very strange way. I don't get it. It hasn't been litigated that I know of, but I think it would be very questionable to say that a schematic diagram, again, not as a trade secret, but as a matter of copyright. And there's been some attempts to litigate against repair shops that have gotten access to copyrighted schematics. So it's not a trade secret issue, it's a copyright issue, if that makes more sense.
I can see this argument, what you just explained, to be very vividly demonstrated in the case that where certain manufacturers are charging for the manuscript, right? So it's essentially a price discrimination. Some of them are getting that, but others have to pay a little more. And then there you would be able to see the argument about trade secret and even copyright is not so much valid. But perhaps there are things that beyond that, like for anyone, you said the manufacturer are not going to put their trade secret in paper and then sell it to a subset of consumers, right? So is there some issue around that? Like, some consumers are if they are capable or think they're capable, and they just want to know things that's not already on a manuscript, and is that part of the current discussion about right to repair, or is that's actually not part of it?
Well, it hasn't been part of it because consumers as owners have that bundle of rights that you were talking about. So it's not the choice of manufacturer to tell a consumer that they are competent or not competent. It's the owner that gets to decide on competency. So if you feel that you are competent, why can't you get this information? If your nephew you think is more competent, why can't he get the information? If you want to use a local repair shop, they should be able to get the information, because it's you as the owner have that choice. You're the only party that has to be satisfied with the repair. You can bungle a repair and it doesn't hurt the manufacturer. They'll cry and say, "Oh, my brand image," and that's a whole other issue. But consumers are not, as owners, are not required to care about the brand image of the manufacturer. If there's a law out there that says I have to care, I have not seen it.
Okay, I think
so it's a lot of these things just fall apart on the question of who owns the equipment.
So I think we've unpacked just exactly what right to repair is. It's obviously sort of become top of mind amongst policymakers, top of mind for you for a decade now. But most recently, we have seen increasing publicity around the issue. Can you tell us a little bit about the history, I guess, of your association's grassroots movement and how you sort of see that coming to a head today, and what you're seeing in the the public light today around the attention to right to repair?
Sure. We really got our inspiration from that Massachusetts automotive right to repair. We'd been struggling as independent repair companies, all sorts of different independent repair companies, struggling for a while to figure out how to basically survive, because we were being pushed out of almost every corner. Every time a manufacturer would come out with a new product, it would be one of those products that couldn't be fixed, either by glue or policy. And once that Massachusetts law was passed, we said, holy cow, that's perfect. It only has one problem. It says automobile. And we said, this is the model. We're just going to, so we literally incorporated a nonprofit trade association that was using that business model or that legislative model in states. And we haven't turned back. I mean, it has been very effective. It's taken far, far longer than I ever dreamed. I thought I'd have a bill passed in 2 years. I mean, boy, was I silly. But I thought it would be a piece of cake to go back to Massachusetts and say, hey, you already did this. Let's just make it a little bit better. And instead, the legislatures in Massachusetts said, oh, no, not again. So, yeah, it's been quite a long process. And that's because state legislatures are small. They are short sessions. Every one of them has got their own policies, their own procedures, their own cast of characters, if you will. And we've been stopped by all sorts of stuff. We had a bill sponsor that died of a heart attack. We had another situation. I mean, not to even mention the pandemic, but we've had every kind of disaster that can possibly befall a piece of legislation having nothing to do with opposition. And then on top of it, you add the opposition. You can see why it's been a little longer. But it has become very top of mind because everybody feels it. Every legislator I sit down with, somebody in that room holds up a broken cell phone. Everybody does. And they say, oh, like this? And they hold up the phone and we say, yeah. And at that point, we've already convinced them. They are already signing on to the bill because they are that frustrated. And then all the other discussions come up talking about, oh, yeah, and I couldn't fix my dishwasher. And, oh, yeah, this guy down the road, he's got a tractor and he's telling me he can't fix the tractor, et cetera, et cetera. So it's been very easy to get support. It's just been hard to get the bills to the floor for all the practical and obvious reasons. You know, we've got some really big companies in opposition, and they can and they do play dirty. So,
and you mentioned sort of state being the driving force, state legislators being the driving force in the first instance. You know, what are states doing today, and what, if anything, is the federal government doing, or have they done in this regard?
States have the power of UDAP and general business law, and that's the statute that was used, or statutes that were used in Massachusetts for automobiles. So we pretty much just copied that whole approach. It seems to have held up. It seems to have done well, provided an adequate solution, and it has not been challenged in court, which is also helpful to know. Federally, the federal government, until very recently, was totally disinterested, as far as I can tell. We've spent a lot of time with the Copyright Office trying to get copyright exemptions approved, and we've been very successful at that, but the exemption process is every 3 years. It's very tedious. We keep coming up against the same arguments against repairing game stations as gaming equipment is a real hot button for the entertainment software industry, and they're very resistant to letting people repair stuff. But otherwise, we've been pretty successful at getting exemptions to breaking what's called DRM, which is locks, software locks that prohibit repair. So the Copyright Office has been pretty cooperative, but we have not had much until the Federal Trade Commission got involved in 2019. In July, they hosted a workshop called Nixing the Fix. And the intent was to get evidence, and we were asked for evidence, not just a statement of this is bad, but we had to prove it. And we participated in the Nixing the Fix workshop. We provided as much evidence as we could, and then it went dark. We just did not hear from them for months and months and months. And in around March, of this year, in 2021,
2021.
yes, 2021, we heard that they were going to be producing a report, and we were like, "Hey, this is really cool. What are they going to say?" And we had to wait, not knowing. It was really very, very tense. And then we read the report, and I was so excited because it's like they heard us. They actually listened to us. They heard us. It was so great. And that report really elevated the argument, I think, nationally, and it will help the states. I mean, it came out in May of 2021, and at that point, almost all of the state legislative sessions had concluded. So it wasn't helpful for this legislative year, but it's really going to help for 2022. In terms of the awareness and the confidence that this brings to legislators who want to be able to fix their stuff, and they're just in the back of their minds, they're thinking, but I'm going to be hurting something. What am I hurting? And the FTC is basically saying, you're not hurting anything. Fixing is something that is a right of the owner, and states are appropriate to manage this legislation. Now, federally, we have a couple of bills that have been filed that are outright right to repair bills. Senator Wyden out of Oregon put up a bill, I think a year ago, early in the pandemic, specific to medical equipment in the Senate, and it has not gone anywhere. And I don't think at this point I can't predict. I don't know enough about Senate politics, but it seems to me that has not been momentum on that bill. Our former bill sponsor in New York State, Joe Morelli, he was our first bill sponsor when he was the majority leader in the New York State Assembly. He has filed essentially the state bill that he championed. He has filed it in Congress. He's a freshman congressman. Again, great bill. Why would we complain? We wouldn't complain. But again, he's a freshman congressman and don't know how far any of that stuff can go. The federal government it's so hard. All the moving pieces are so hard. And I think the opposition lobbying is so entrenched that it's really hard to get the attention of somebody that's being courted by opposition lobbyists. I think it's much, much harder to get them to change their mind than it is at the state level, where somebody can get $25,000 together from friends and neighbors and get elected.
Mm-hmm. Let me get a little more precise with the things that we're looking for here, right? In terms of legislative reforms or policies, or even just aggressive enforcement. So, are we looking for some improvement on the laws, or are we looking for just a better enabled, consumers and to be better protected and enabled under the existing laws?
I lean towards the better protected. I think there's a lot of laws that already exist that provide lots and lots of ways to enforce various aspects of the Sherman Act, such as the failure to the resistance to selling parts, the exclusive dealing aspects, the tying agreement aspects, where the sale is supposed to be a complete sale and you're not supposed to have to buy another product in order to use it. Well, all of these repair monopolies are very much in violation of that, because in order to keep using your product, you got to buy something, which is a service from the manufacturer that is not available competitively. So there are lots of places where the FTC could be enforcing existing law, but I think state law really state law can do it. Let's call it 80 to 90% of what needs to be done is something that is under the control of a state general business law, a UDAP statute. All of those things are resolvable. It's the copyright issues where there are still a lot of points where manufacturers can say, you can't get this because it's copyrighted. Those are things that have to happen federally.
And I want to just cover, I guess, one last bit of substantive corner that I have here. So consumers and consumer advocacy organizations like the great organization of yours are very much in this movement. What about third-party vendors, like who feel like they may be able to be part of the business if they are provided with the parts and manuscripts, they would be able to provide some competitively priced repair services, for instance. Have they been part of this movement?
They were the spark plug for the movement because these businesses have been around for a long time. I mean, I used to sell maintenance contracts with mainframes, and they were available from lots of different parties. So the businesses exist, and they've been getting slowly picked away, as I said, by the limitations on access. So yes, they're very excited about being able to restore a business model that was very functional and expand it and grow for a change. Because here we have the situation where the number of gadgets in our lives is growing kind of exponentially, but our ability to keep them in use is diminishing almost exponentially. We're getting to this huge gap where very few of the things that we buy can be maintained in use. They don't even have to be broken. They just have to have a battery. That's a consumable. It's like buying a printer where you can't replace the ink. How long is that going to last? Well, you print too many pages, you're going to be buying a new printer. Of course, that's a business model that a lot of people don't like right now. But extend that to the consumable, which is effectively a battery, or something simple like a piece of glass. I mean, if you break your windshield on your car, you don't go trade in your car. You just get the windshield replaced. And some of these prohibitions are so ridiculous that that's the kind of thing that people are being asked to do. And as the products get more expensive and more integrated in our lives, it's harder and harder for people to just say, I can't spend that.
Again.
Again and again.
Yeah.
And keep spending it and you look at the affordability issue. And I know it's it sounds like it's maybe politically pandering, but it's really quite true. There's a huge segment of our population that can't afford the first one. Mm-hmm. They don't have $1,000 to spend on a cell phone. If they could scrap together $200 for a used cell phone, that brings them back into the digital world. So we've got to have a long-lasting, functional, used marketplace to support the less, at least I'd say half the population that has a big affordability problem. So,
yeah.
Great. Well, guys, this has been very informative.
It's one last.
Go ahead, Nora.
One last thing. Yeah, I'm sorry. We probably need to cut the last 5 seconds. Any predictions? Are you hopeful? Do you think this is rather than fixing the phone or tractor, can you fix the world that we're in 5 years, perhaps? Any predictions?
I am very hopeful. I am really excited. I think all the work that we put in and the momentum that has been generated this year, it's like everybody's pulling in the same direction. Everybody. Well, with exception of a couple of billionaires, but everybody wants to be able to fix their stuff. The environmental community wants people to be able to fix their stuff. All the sustainability people know that it's crazy to throw stuff away. We've got the political willpower. We've got a nonpartisan, very, very popular bill, 75 to 95% approval rates every time we poll it. And I think this is our year coming up. I think 2022. And again, there's always something terrible that could happen, like another wave of pandemic or something. I don't even want to suggest that. But barring any really horrible complications, I think we're going to get several bills passed this year in states. And that will cause a cascade of good things that may or may not come to the federal space at all.
Great. Well, Gay, really appreciate this. This has been very educational, and we're excited to see what happens in the upcoming year. Before we let you go, we do like to ask all of our guests some questions so we get to know you a little bit more personally. First, if you could tell us something about yourself that we wouldn't know about you if we only knew you professionally.
I'm a big skier.
Cross country or downhill?
Oh, downhill. I love going fast. I turned out to be a speed freak. If I can go to those auto places where you can go as fast as possible, I'm in. I never knew that.
Well, that doesn't surprise me. I don't know. A trailblazer for sure. And then I guess now to our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So, Gay, can you pick a number 1 through 25?
17.
17. What was your favorite course in school? I guess college, grad school, whatever.
College, Russian history.
Ah, okay.
Absolutely loved it. My favorite professor, just couldn't get enough of it.
And is there a course you wish you had taken in college that you didn't take?
I pretty much got what I wanted.
Okay, fine. Favorite Russian literature piece?
Oh, God. Oh, dear. Tolstoy.
Okay.
War and Peace.
It's a classic.
It's a classic.
Okay, thank you again for joining us on our episode, Our Curious Amalgam. And to our listenership, thanks for listening.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.